Diaz.
Good morning. Oh, wait a minute. It's still, hang on. Setting up.
Chairman.
Live streaming. And we're live, ladies and gentlemen. So
Mr.
welcome.
Chairman, excuse
Sir.
me. Which one is Wyville at the bottom, to the right or left?
He's in the middle.
I shall
He's the one
Alert.
not moving.
I heard that, Filiberti.
I shall alert you all that we are on live stream now. Okay.
Done.
So let us do something different. Be on your best behavior.
Oops.
Thank you, ladies and gentlemen. This is the meeting on February the 24th, Housing and Real Property Subcommittee. We have several bills to discuss this morning. There are two bills that are on the list where we are expecting amendments. And what I will need to do is to hold those two bills that we don't have amendments for just yet, just because they're in the process of being prepared. Matthew, if you would do me a favor, please, and let's discuss the two bills right now where we have to hold until we get the amendments put together. Let's do that first.
Oh, sure. So the first would be HB 567. That's a local Montgomery County bill. It's for reserve studies for common ownership communities. In reviewing the bill, I noticed that there was some information that had been dropped in the amendment in terms of condominiums and HOAs that was intended. It was added for cooperatives. It was not added for condominiums and HOAs. So the staff for the delegation is looking into that, and there possibly is going to be an amendment to make sure everything is consistent. The other bill is.
But hang on a second, Matthew. I just want to, because, well, I just want to be specific on this bill and what is happening, because we've already had one reserve study bill re-referred back to committee. I want to make sure everyone understands that that is not the case on this bill.
Yes.
The reason why there's some inconsistency in the language that needs to be clarified. That's all. This bill is coming out as soon as the amendments get taken care of. And what Matthews is letting us know is that one part of the bill is condominiums, the other part of the bill is HOAs, and that language for both need to be consistent. It is in the condominium language. It is not in the HOA language. Okay, that's what
it's in the cooperative language. It's not in for condominiums or HOAs.
Got you.
Slight
Okay.
correction. Yeah.
Okay. All right. So that's that one. And the other one, Matthew, is which one?
The other one is HB 861. That, as you might remember, is the tenant reusable tenant screening reports bill. That had a number of amendments that were being offered by CDIA, and that group is working with the sponsor to put those amendments together. As I understand, in speaking with the sponsor, they're fairly extensive. So at this time, any discussion on that bill would be substantially changed once the subcommittee has the full amendment. So it just at this time seems most practical to wait until that amendment is ready.
All right. So that reduces our workload by 2 bills. All righty. So now let us begin with HB 248. HB 248, ladies and gentlemen, is for condominiums and HOAs. And this bill is relevant to composting. We've had a lot of discussions on this last week as well. And I do believe that is there an amendment on this one? I think there's an amendment on this one. Is that correct, Matthew?
Yes, there is an amendment. That amendment is HB 0248-660719-1. It should have been in the email I sent around 9 o'clock this morning to the members of the committee. or the subcommittee. Just going through what the amendment does. The first amendment is technical, makes changes to the purpose paragraph of the bill. The second amendment adds the unreasonably restricts language that the subcommittee had discussed previously. And then for the next two amendments, if it's possible, would I be able to share my screen? Because it might just help to visualize.
Oh, yes. That'd be great. Let me see if I can. Let me go here.
I think I might be a co-host, so I might just be able to. Oh, never mind. I'm not.
All right. Let me see here. How do I do that? I go restrictions. No. How do I allow you to do that, Matthew?
I believe if you hover over my my tile, there should be the option to share screen. If not, if not, they're not too difficult. So I'll be referring to the reprint of the bill. If everybody has that in front of them.
Oh, okay. I opened up the wrong one.
Okay. This would be the reprint with 660,719 included. Amendment number 3. So amendment number 3 requires that anybody in a homeowners association who is actively engaging in composting observe all laws, ordinances, and regulations of the state or local jurisdiction that pertain to composting.
Is it showing up?
Got it.
Yes, it's showing up now, and this would be on page 3 of the bill.
Okay.
And line 4.
All right. Let me page 3.
Page 3 and line 14.
14.
Okay.
That it?
And so it starts in line 14, and then line 21 is where the change is where an additional change occurs. So anybody who's actively composting organic waste materials for the lot owner's personal or household use, there may not be a prohibition or an unreasonable restriction so long as that individual is observing all laws, ordinances, and regulations of the state or a local jurisdiction. So that would include the counties and the municipalities in which the homeowner association is located that pertain to composting. Amendment number 4, and this was discussed with the delegate who sponsored the bill, strikes language with regard to active composting in a condominium, maintains language allowing unit owners to contract with a private entity to collect organic waste materials from the unit owner for processing offsite at a composting facility. And that language is purely one of practicality because there is limited green space in which somebody might actively engage in composting in a condominium. And the sponsor noted at the last subcommittee meeting that more likely, as a practical matter, those engaging in a condominium who compost would likely be contracting out with a third party to manage this. And those changes take place on page 2.
Oh, wait a minute.
Everybody needs to mute themselves.
Yeah, I'm going through it here now. Go ahead, Matthew. Continue if you don't mind.
Oh, that was the explanation of the amendments. So
Okay.
Yeah, happy to take any questions.
And these amendments and the bill as amended allow composting for all common ownership communities. Is that correct?
They allow, no, there is no language.
It's only condominiums and homeowners associations.
That is correct. And the language specific to what I guess I will call active composting or composting by the unit owner in a condominium was stricken. So the bill as it's amended would would create a prohibition against any prohibitions or unreasonable restrictions on contracting with a private entity to engage in organic material collection for the purpose of composting at a compost facility. So I apologize for the double negative.
Jen?
I didn't get lost in the double negative. I got lost in the piece you said before. Who's not allowed to compost?
Cooperatives.
Those in a condominium. It's not that they would not be allowed to compost. A condominium, the council of unit owners of a condominium could come together and elect to create a small composting site at the condominium if they so choose as part of their normal process. But in a condominium setting, the council of unit owners or the board could prohibit the unit owner themselves from having a small compost site. And again, it's purely a practical matter that was identified by the sponsor, where those living in a condominium, especially like a high-rise condominium scenario, or they're not going to have a space really where they could, a space that is their own, or they're unlikely to have a space that is their own or subject to their exclusive control where they could compost.
But, okay. Wait, but they can still have a compost bin on their deck.
They could still have a bin to collect waste scraps for collection by a third party and processing at an off-site facility.
Okay, but I just want to point out what I'm sure folks know, but seems to be not the way we're talking about it, is that condominium is not a type of building, but a type of ownership.
That is correct.
So, like, for example, we have townhouse communities that are condominium owned in Howard County. I'm
All
not
across the state.
sure I know of HOA owned apartment buildings, but we definitely have condominium owned townhomes. So I'm not sure I completely understand that lot. Like, I don't understand. I don't know, was the sponsor okay with that piece? Because that piece confuses me a little bit.
This was an amendment that was worked on with the sponsor.
Okay.
And run by the sponsor and developed with the sponsor.
Okay. I just, for what it's worth, I'm not so sure about carving those folks out, but I will, if the sponsor's okay with it and everyone else is, I guess. But that concerns me because it's not a type of building, but okay.
Mr. Chair.
Yes,
Yeah,
sir.
I would agree with what Delegate Terrazza just said. I mean, I guess if the sponsor's okay with it, but I would just echo what she said. If the sponsor's good with this and this is what the sponsor wants, then okay.
I agree. Same thing. I agree with my colleagues all the way through.
Ditto.
Me too.
All right, we have in front of us the amendments. All in favor of the amendments signify by saying aye.
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 All opposed to the amendments signify by saying no. Any abstentions for the amendments? Seeing none, the bill is before us as amended. Move the bill as amended. Is there a second?
Second.
All in favor of the bill as amended signify by saying aye.
Aye.
All opposed, say no. Any abstentions? HB 248 passes as amended. All right, we will now go to HB 541, ladies and gentlemen. HB 541 is a Montgomery County only bill that was brought to us by the Montgomery County delegation. And it is a bill relevant to school district information. Any amendments on this bill, Matthew?
There were no amendments that I received, and none were offered in testimony.
Any questions on HB 541?
None.
Hearing none, is there a motion for favorable? I'll make a motion for favorable on HB 541. Is there a second?
Second.
Any opposition? All in favor signify by saying aye.
Aye.
All opposed, no. Any abstention? HB 541 carries as proposed. The next bill we're going to discuss is HB 784. HB 784
Excuse me.
has a is sponsored by a very popular young lady in our subcommittee. And HB 584 is a bill relevant to electric vehicle charging stations. And there are amendments on this bill, as I understand. Is that correct, Matthew?
That is correct. I can explain the amendment now or go over a brief review of what the bill does.
Let's just do a brief review first, and then explain how the amendments reflect or change the bill. And then I'd like to have Delegate Terrasa speak to the amendments and the bill as well. Go ahead, Matthew.
Sure. So the bill the bill requires a builder or the builder's agent of specified new housing units, which is examples in the bill are provided. That would be a single family detached home or townhouses. Provide a buyer or prospective buyer with the option to include in or on a garage, carport, or driveway, either an electric vehicle charging station or a dedicated electric line of sufficient voltage to support the later addition of a particular charging station. Now, the amendment to the bill was offered by Tesla. The language as drafted in the bill was specific to a particular SAE standard for electric vehicle recharging stations and connector types. The language as provided here with the amendment, and the amendment number is HB 0784223-822-1, would have a more general requirement, still require that whatever level 2 charging equipment meet applicable industry safety standards, but rather than require something with a specific connector type, would include the ability to charge an electric vehicle's battery or other energy storage device through means of an alternating current electrical service with a minimum of 208 volts. So less specific to a type of equipment, more specific to general, or more in line with general requirements for level 2 charging.
And that's the amendment on page 2. Is that correct, Matthew?
That is, yes, the amendment on page 2 would replace language that's currently at lines 5 and 6 pertaining to the definition of level 2 charging.
All right. I attempted to put that on the screen. Can you all see that?
Yes.
Yep.
Okay, great.
So that, I'm sorry, may I ask you a question, Mr. Chair?
Sure.
So that, Matt, that's the Tesla amendment, and it just makes it a little bit more broad, so we don't get locked in anything specific, correct?
That's
Right.
Yes, that's my understanding. I think the intent of the original language was that there are a large number of manufacturers that use this connector type, but this does just generally make it more of a general standard and less technology specific.
Good, okay, that makes sense, makes total sense.
Jen, you want to, I'm sorry, go ahead, Matthew. Let me cut you off, Matthew. Go ahead.
I was going to say there was also a recommended change that was included by the builders, but there was that by MBIA, there was not specific language. I think maybe it'd be best to allow Delegate Terrasa to explain the amendment a little bit more in the background on this amendment from Tesla, and then go into the MBIA recommended language. So
Jen?
Yeah, thank you, Mr. Chairman. Yeah, I think that was a great explanation. And then with Delegate Fraser Hidalgo's question, I think that covers it. I mean, it's just not specific to a particular technology and leaves it open to changing technology, but still making sure we have level 2. So I think that made sense to me. I mean, I just want to remind everybody that this bill did pass this way last year. Oh, sorry, my computer's about to be out of charge. So I just wanted to remind folks of that. But yeah, that's basically it. And then I guess we're going to go into a request. Did you have a requested amendment?
Well, there was a request included in. I will just refer to the subcommittee to the MBIA testimony, and it was about a grandfathering of properties. So I'll just read straight from the testimony. We propose that this legislation be given a grandfather clause that would allow for the completion of projects already underway while simultaneously requiring new projects to offer property buyers the opportunity to install EV stations. I will note that and of course I can't find my copy of the bill right now. Yeah, here it is. I will note that the bill, I'm just referring to section 2 at the bottom of page 2. This act shall be construed to apply only prospectively and may not be applied or interpreted to have any effect on or application to any new construction for which a building permit is issued before the effective date of this act, the effective date being October 1, 2021.
Let me go to members of the subcommittee first, and then we'll go to the stakeholders. If you're finished, Jen.
Well, there has been subsequent conversation. I spoke with BGE and they did not have any concerns about this. From my conversation with them, my understanding, I know the builders are still concerned, no, maybe they'll tell you if they are or not.
Yeah, we'll get to them after the subcommittee.
But my conversation with BGE is that it's frequently the case that things change along the way. I mean, this wouldn't be any different than if you wanted to add another, like, let's say you wanted to add a second stove, maybe in your basement for, a mother-in-law suite, or to add another, I don't know, my dad's neighbor has a second stove just in case they have extra, wanted to have more people at a cocktail party, for example. Like, this is, if you have, this is very similar to that type of outlet, and the type of load that you would have is the same type of outlet for a dryer, and the same type of load that you would have for a stove. So BG didn't have any concerns, and it seems like the clause that Matt read would cover things.
Bill?
Yes, thank you. So I thought last year's bill, they only had to provide information, but this year's bill actually, because when I'm thinking about when you're, looking to buy a house, you have options of upgrading flooring or cabinets and all that. The way I read this bill is the builder actually has to have that option of upgrade for the charging system. So I interpreted this year's bill as being different from last year's, but Jen,
No.
I just heard you say it's the same as last year's.
No, to clarify, last year, the way the bill was filed required them to be installed, either to install the connectivity for it. The way it passed was exactly as it was filed this year.
Okay,
Which was just as a mandatory option. But it was introduced as actually requiring the infrastructure, and also included townhouses and multifamily housing. But this year it's just single family homes and townhouses, garage townhouses, and it's just a mandatory option.
What you say mandatory option, what do you mean?
Mandatory option means, well, I would have liked to have seen it, I would have liked to have seen it as mandatory. Mandatory option meaning they have to offer it as an option to the buyer. So the buyer.
Well, I can tell you, having been one of those guys in the model home where you walk in to buy your new home, a mandatory option is just a list of things that you can offer. A sunroom, okay, different color countertop, So that's on the option list that you can choose. You have to pay for it, but it's an option that you can choose
Right.
from.
So all of those other options, are any of those mandated by state law?
That I do not know. That's a very good question, Bill. I do not know that. I've got Lori on the list to talk after we get to the subcommittee.
Yeah,
But
because I mean, I voted for this bill last year, but I do have some concerns about the state being too much in the weeds and mandating, specific items on contracts and stuff. So that's why I'm asking if these other options are also mandated by the state or not. So is there somebody that can get an answer for
yeah,
us on that one?
we've got Lori here with us. I'm sure she has an answer. But let me
Okay.
let's get to some of the subcommittee members
All right,
before we
thanks.
get to the stakeholders. But that Lori, make a note of that question if you don't mind. And next we'll go to Delegate Lehman.
Thank you, Mr. Chairman. I don't have a question, but having brought this bill last year with Delegate Terraza and knowing how much stronger the original version is, I'm prepared to make a motion favorable. I think this is really straightforward. Look, I argued last year as the English major in me, like mandatory option it's a non sequitur. It sounds ridiculous. I think everyone gets the concept. People are smiling. It sounds a little odd, but it's that the builder has to offer it as an option. And that's all. It's not really anything more complicated than that. And I think we should move this bill out today.
Yes, ma'am. Delegate Fraser Doggo.
I agree. I don't understand why we're having all this conversation. I think we hashed through most of this last year. I think that the Tesla amendment is a good amendment that makes it more of an open source, so anybody can get in whatever they want. I don't understand why there's so much resistance. I'd be very curious to hear if there's like a lot of resistance to this bill. I mean, I actually supported the bill as it was originally submitted last year. I don't know why we're having all this conversation. It's really not a big deal. It really isn't. I don't get it. I just don't get it.
Well, let me explain, since we're on a live stream here. We're having conversation because that's part of our legislative process. That's all. I am as chair and no means suggesting that the bill be stifled and or killed. I am having the discussion as a normal part of the legislative process.
I appreciate it, Mr. Chairman. I did not mean to impugn you in any way whatsoever. This is more for some of the members that are asking the same questions that we asked last year, and we went all the way through this. So anyway, I'll leave it at that.
Actually, all due respect, I didn't ask the question last year, and I think it's verified by the fact that no one knows the answer to that question. If you're referring to the one I just asked.
I wasn't
Lori,
question.
hang on. Lori, you're up, please.
Hello. So a couple things. First of all, I don't believe anything else is mandated, but I will double check that for you, Delegate Weibel. And the other thing is, you may be recalling Delegate Fraser Hidalgo had a bill a couple of years ago that did mandate giving information about electric or energy efficient options. And that was a bill that was a couple of years ago. So that did pass. So yeah, our only concern, we're not opposed to this bill. Our only concern was that existing projects, and we went back and forth with BG&E on this, and there, for existing projects, there may be some small issues as far as redesign and stuff like that. But I talked to them about 10 minutes before this meeting, and I think we're all on the same page, and we're good with the bill as it is.
I move the amendments to HB 784. Is there a second?
Second.
All in favor of the amendment signify by saying aye.
Aye.
Opposed, say no. Any opposition? The amendments have passed. I move the bill as amended. Is there a second?
Second.
Any opposition to the bill as amended?
I'm going to vote no, only because of my questioning of the state being involved in the detail on, of these contracts.
Thank you, sir. We have one opposition. And is there any abstentions on the bill as amended? Thank you very much. HB 784 passes as amended. I want to make sure, Shirley, that you put Neil as an excused absence. He did call me earlier. So we have him as an excused absence, please. We will now go on to HB 825. HB 825, ladies and gentlemen, is a bill sponsored by one of our own. And we've heard this bill previously as well. HB 825 is relevant to only to co-ops in the state of Maryland. And its topic is settlement and eviction procedures. Matthew, you want to talk to us about this bill? I do not believe that there are any amendments to this bill. And this is a bill that we had before us last year. Matthew?
Yeah, there are no amendments to the bill. The bill wasn't before the subcommittee last year, just a small correction. It was HB 414 of 2019. However, the bill is in the same posture as that bill, same third reader version that passed the House unanimously amongst those present. And generally what the bill does is the bill changes dispute settlement mechanisms under the Maryland Cooperative Housing Corporation Act, making it a little bit more flexible. And I don't like to use the word flexible because it makes it seem like it's a weakening. It's as I understand it, reflecting realities where it is hard to where a hearing may be required or a mandatory hearing may be or is currently required. However, often the alleged violator in a dispute doesn't show up as at the hearing. So this makes the hearing requires the cooperative to give notice of the opportunity for a hearing. The violator would then have to request that a hearing be conducted, and then the hearing would be scheduled the same at least 10 days after the request for a hearing is provided. It also makes.
Go ahead.
I'm sorry.
Go ahead.
It also makes changes to the application of when and how a cooperative can go about using traditional failure to pay rent actions for the collection of assessment fees.
Thank you, Matthew. And as indicated, this was a bill that was passed in 2019. I guess the sponsor was asleep at the switch on 2020. And did you want to say something about HB 825?
It's identical to the bill we've passed before, and there's a companion bill for the other two forms of common ownership. So the main point of it is the dispute settlement. The eviction procedures wording in the title is unfortunate, but it's because there were things that were added mistakenly in the past, and it's just cleaning them up. And that's all it is. And as I said, it passed unanimously in the past. I don't see any problem with it. It did not pass the Senate before, though. So we'll see.
Is that a motion, Ann?
I move favorable on this bill.
I second the motion. Are there any discussion, please? Any discussion on HB 825? Hearing none, we'll go to a vote. All in favor of HB 825 signify by saying aye.
Aye.
Opposed, say no. Any abstentions? HB 825 passes, and there are no amendments on HB 825. We will now go to HB 826, also sponsored by one of our esteemed members. And HB 826, ladies and gentlemen, is the same type of legislative requirements as we passed on HB 825, only this time HB 826 is relevant to condominiums and homeowners associations. And the reasons why there had to be two bills is because those types of ownerships and or timeshares are different on the two pieces in the real estate article. And there are no amendments to HB 826. Matthew, you want to give us an additional discussion on HB 826?
Only to say that, like the last bill, this bill is a reintroduction of prior bill from the 2019 session. That bill would be HB 392. And that bill also passed the House unanimously amongst those present. There were no changes between that third reader version and this version.
And on this one, the sponsor took a nap in 2020, but came back in 2020. You want to talk?
I took a deep breath. I took it. Not a nap. All right.
You want to speak to your bill, Ann?
I think it's been explained well. I'd just like to move favorable on it again.
Second, is there any discussion on HB 826? Seeing none, all in favor of HB 26, signify by saying aye.
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 Opposed, say no. Any abstentions? HB 826 passes. Thank you, Ann.
You're welcome. Thank you.
We will now go to HB 942. HB 942 is a bill we heard recently in full committee. This is a bill sponsored by Delegate Conaway. And the bill is entitled Commercial Leases, Ground Rents for Termination by the Tenant. And they're
Grounds, not ground rents.
ground rents, as we all know.
Not ground rents.
No. Okay, that's my cue to mute myself, I assume. Okay. For those of you who are live streaming, this is an internal joke about King Charles I and established in 1634. Anyway, this bill was heard recently, and we have there has been some opposition to this bill, and I would like to ask Matthew, are there any amendments that were proposed on this bill? I recall that there may have been. Matthew?
There were no amendments offered in testimony. Let me double check just to make sure I didn't receive any amendments. I apologize.
Take your time, take your time. David?
Thank you, Mr. Chairman. Just, is there a way to do, I'm reading the synopsis of the bill now. Can we just have a quick conversation about what the intent of this bill actually is?
Sure. Matthew, you want to give us a brief description on the bill?
Sure. So just to verify, I don't seem to have any amendments. The bill.
And while you're talking, Matthew, I'm going to be looking as well.
Okay. The bill would preclude a landlord from, or prohibit a landlord from charging a tenant or causing a tenant to be charged for electricity usage, except in accordance with the terms of a written lease. It's only applicable to, it's applicable to non-residential tenancies. So this would be commercial or industrial tenancies. Now, if after receiving notice that the landlord has violated that prohibition against charging for electricity, unless, if after receiving notice that the landlord has violated that prohibition, a landlord commits a second or subsequent offense, it would allow the tenant to terminate the lease without any sort of penalty. That termination would take effect immediately upon the tenant providing written notice of the termination to the landlord.
All right. As you were speaking, Matthew, I was scrolling through my laptop here to see if I could find any amendments. I could not. There were several persons. Any questions from the subcommittee on HB 942? We have several persons, several stakeholders here in our meeting that had testified during the full committee meeting on HB 942. And I'd like to give them the opportunity to speak. I see Lori Graff here from the Building Industry Association. Lori, did you want to speak upon 942?
I'll defer to some of the other stakeholders.
Okay. Is there anyone that would like to speak on HB 942 as stakeholders? I see, Tom, you've unmuted yourself.
Okay. Raise my hand, Mr. Chairman.
Go ahead.
Tom Ballantyne with NAIOP Maryland. We're Commercial Real Estate Trade Association. I sent a quick summary yesterday of our position on this bill and 960. As we understood the hearing testimony, this was a result of an incident where a landlord was stealing electricity from a tenant. And we feel like that's a matter for the court to sort out. And the bill gives a immediate right, or at least after notice, a right to terminate the lease, which we thought was a kind of a disproportionate outcome and the wrong remedy. So we thought it was a bill that really needed a solution in a different venue, and we have opposed for those reasons.
All right. I was searching for your letter, Mr. Ballantyne, as we were speaking. I apologize for me being so clumsy, ladies and gentlemen, in finding all of these things. There you go, right there. Can you see that, ladies and gentlemen?
Yes, thank you.
All right. Let me see if I can expand it a bit.
Mr. Chairman, I don't know if you saw, but Mr. Enton had put his hand up.
Oh, I did not see that. Mr. Enton, you want to speak on this bill, please?
I would. Thank you, Mr. Chairman. I join with Mr. Ballantyne. I mean, to have an automatic ground for termination. We're talking about commercial leases. These are business-to-business relationships. And, it seems to me if there's a dispute under the terms of the lease, this is, either business has the ability to go to court and get it settled, but to have a right of automatic termination. I can tell you in 30 plus years of representing landlords and 20 plus years representing the builders, I've never heard that this was ever a problem before.
Okay. Let me do this. Are there any other stakeholders that want to weigh in on this particular bill? If not, I would like to open this up to the subcommittee for discussion, or what is your opinion, subcommittee, on this particular bill? Is there?
I would move unfavorable.
We have an unfavorable motion and we have a second. Is there any discussion on the unfavorable motion? Hang on a second. I see Jen has her hand up in discussion period on the unfavorable motion. Jen?
Yeah, I guess, thank you, Mr. Chairman. I hear that this is they're saying this is too big of a penalty, the wrong remedy, but I guess there's such an imbalance of power between a landlord and a tenant. Like, I'm not sure I understand how going to court is the right remedy. And if it's not a problem, a frequent problem, then what would be the problem having this remedy here in the background in case it becomes a problem again?
Oh, thank you. I have to increase your salary.
Mr. Enton or Mr. Ballantyne?
I think the bill does has another aspect to it that concerns us, is that at this point you'd have to begin to really define the pass-through costs that are part of common area charges, and the imbalance that you described is either really not there to the same extent in commercial leases as it might be in residential. Both sides are represented by professional parties. They negotiate the terms of the lease, and the remedies are spelled out in the lease. Immediate termination for a dispute over what kind of how costs were distributed to existing tenants is a real concern for us.
Well,
I will add that having done commercial leases as well, you'll find that there's a huge difference between residential leasing structures and commercial leasing structures, that there are not even standard boilerplates utilized for commercial leases. When I do a commercial lease, it's with attorneys on both sides. Because they're hugely different between residential and commercial. Hugely different.
Mr. Chairman, could I comment on the question?
But let me make sure that Ms. Tross, Delegate Tross is complete first.
Well, yeah, just to follow up, and then Mr. Enton, I'm interested to hear what he has to say about it as well. But I mean, I hear that there's often attorneys on both sides, but is that true? I mean, the commercial tenants that I've dealt with are often small business owners, restaurant or other, those types of owners. And they're usually, from my perspective, less sophisticated owners. And I'm concerned, and I guess I wonder what type of remedy a lease has, a commercial lease has for charging for electricity.
All right, Mr. Hinton, go ahead.
Thank you. I think that regardless of what the lease does with electricity or doesn't do with electricity, and I think, some leases deal with it, the lease is going to deal with it one way or the other. But to have a piece of legislation which says that one party to particularly even to a contract, including a commercial contract, I send you 2 notices that if you don't do what I want, then I can terminate the contract. And that's what this bill says. And I think that's completely, totally unprecedented. I've never heard of any piece of legislation that says one party to a contract sends another party a notice. And then if they send 2 notices, that the contract is terminated. As to the comment about, these are business to business relationships. You could have a shopping center that has a Walmart in it that's only got 3 other stores in it. And if you don't think that Walmart has as much leverage with the landlord maybe more leverage with the landlord than the landlord has with Walmart, that's just not the reality. But regardless of the size of the business, whatever, to pass a law which says send a notice and the contract's void, regardless of whether it's true, not true, whatever, to me would just be not the appropriate thing to do when we really do. And I would also point out there wasn't one witness in favor of this bill. Mr. Chairman, I think you're muted.
Yes, thank you very much. We have questions from Delegate Wells and then Delegate Fraser Doggo. Delegate Tressa, did you have another question after this? No, okay. Let's go to Delegate Wells.
Thank you, Mr. Chair. So kind of a little bit based off of what Delegate Taraz was asking, and I'm looking at it. It says if after receiving notice that the landlord has violated subsection, so there is like the first notice, and it says basically if the landlord commits a second or subsequent violation. So I don't think that these are arbitrary things. It sounds like there's kind of an agreement that, if that's a word, that there was a violation. And so there's a first one, a slap on the hand, and then it's basically being made clear that this is what the term is. And so if there's a second or subsequent is when this penalty could be used. So I guess the question I'm probably really am asking is, if there is a known violation, what would you recommend would be a proper way for them to address this? And I do not believe that the courts is necessarily the only way for this to be addressed.
So if I could respond, Mr. Chairman, I think that the difference here, Delegate, is that I'm the tenant. I think you violated you're the landlord, and I think you violated the lease. I send you a notice and I said, I think you violated the lease. I don't think the lease allows you to charge me. Okay.
So,
wait,
Bob, no, I just want to say this because the thing is that you and I are where there's a separation here is, to me, I don't read this legislation as I arbitrarily as a tenant say you violated the lease. I read this as there's something in writing or there's some agreed, like we have agreed, and therefore you are violating what we have agreed to do. So that's And you might
I-
disagree with that, but I don't see this as being art, like as I'm a tenant, I woke up today and I'm saying I'm not supposed to pay this bill. To me, it sounds like this is saying this is something that's in writing that I would pay X, Y, and Z, or electricity charges, and then now you're hitting me with some additional ones.
So let me just say it again, that it says that, a landlord can't charge for electricity except in accordance with the terms, whatever those terms are. And now the tenant sends a notice and says, I dispute that, you can charge me as you've charged me. And the landlord, says, I disagree, whatever, okay? And the tenant sends him a second notice. And then upon the second notice, the statute, the bill is clear. It says the tenant may terminate the lease. So you're passing a bill that puts it up to the discretion of the tenant by merely sending a notice with no adjudication whatsoever that they can walk away. And so at that point, if it went to court, the court would say, well, the legislature passed a bill that said you send two notices and you still dispute whether the landlord can do it, then the lease is terminated. That's the problem with the bill.
This is what the section says, and I'll read it because I know that the public is listening. A landlord may not charge a tenant or cause a tenant to be charged for electricity usage except in accordance with the terms of a written lease. So
Fine, I agree.
Written lease.
Hang on, Bob.
So what I'm saying is that, I'm simply saying if there is a written lease, and my understanding is that these leases, all lease in the conversations that we've had are very explicit, right? And so there's explicit terms in that lease. Therefore, it's not some arbitrary, someone could raise and flag, but there would be an explicit way in which you could say, here's what the lease says, and you have gone outside the realms of the lease. So that's the first violation. And then you do it again. The lease is explicit on what to do. So I'm not understanding the argument you're making that this could just allow frivolous claims by a tenant is all I'm simply trying to say.
I'm not saying they're frivolous one way or the other. I'm saying I'm not aware of any contract, a lease or other contract that says that if one party to the lease or to the contract disputes it, then under Maryland law, the contract, if they send a second notice, is terminated.
But can a landlord?
This is a dispute. This takes it away from your ability to if you have a dispute, all I got to do is send you two notices. I dispute it, and now in accordance with this law, it's the
landlords can terminate
terminated.
a lease. They can terminate a lease if there's illegal activity going on. There are ways in which you can terminate a lease, and landlords are able to do that, right?
A landlord or a tenant.
The only thing I'm saying, Bob, is that you're making a claim as if there is this complete power imbalance that you're saying that landlords, you're also kind of admitting that there's never a situation where a landlord can terminate a lease for violation of the tenant. This to me is saying that if there's a violation by the landlord twice in subsequent, that the tenant could potentially violate.
But I think one of the things that, if I can interpret,
that the tenant could, excuse me.
Yeah, I understand. I think one of the things, if I can interpret, what's trying to be discussed here is that if I, as a tenant, say that you, Delegate Wells, has done something outside of this agreement, then I can send you two notices and be out of my agreement. There is in the bill, I don't think that it's, I think what they're trying to say is that usually when there's a dispute, you have someone look at the issues and weigh on one side or the other. And this bill takes it out of someone looking at both sides of the issue to weigh in on whether one side is right or one side is wrong. That's what I think is being said. We have right now Delegate Lehman and then Delegate David Fraser Hidalgo. And then Delegate Terrassa.
Mr. Chairman, I was going to suggest holding the bill if we can't make some headway here pretty soon. That's all.
Delegate Fraser Hidalgo.
I don't know that I have a question at this point. Mr. Chair, I think you answered my question. So
And I want,
I don't have a question. You
thank you
answered.
very much. And I want to remind the subcommittee that we have a motion on the floor and the motion has been seconded. Delegate Tarasa?
Thank you, Mr. Chairman. Is the first part of the bill the part that says you can't charge unless it's in a lease? Is that already part of the law?
I'm not sure if I understand your question.
So there's two pieces to this. One of them is the enforcement piece, which it sounds like there's concern about it not being adjudicated and the lease being automatically terminated, or the tenant can automatically terminate it. But the first part was they can't charge for electricity unless it's explicitly stated in the lease. I need to pull that back.
Okay.
Is that piece already part of the law, or is that part of what this is doing? Like this part that says a landlord may not charge a tenant or cause a tenant to be charged for electricity except in accordance with the terms of the written lease. Is that already the law, or is that something being added here?
Well, I do know that in most cases, when you do a commercial lease, you have it's in the commercial lease, you have what is sometimes referred to as a triple net or a double net or that kind of thing, where the lease specifies if you're paying additional fees for cleaning the parking lot, for electricity, all of that is in the lease, the commercial lease, that is already in there. So I don't think that the part that is adding that to the law, I think that that's already contract law. I'm not sure if it is further expanded by statute. I would have one of the stakeholders expand upon Delegate Strasser's question, please. Bob, you're muted, Bob.
I'm sorry, I don't believe there's any provision under any law that says that that you have to have a term dealing in a lease that deals with electricity. I'm not aware of any leases that don't provide, particularly commercial leases, as who's responsible for what. I guess if it was silent, that could be an item of dispute. But this is a commercial lease. I've never seen a commercial lease in my life as a lawyer, and I've seen many of them that didn't specify the agreement of the parties as to how utilities were going to be paid.
Did you want to expand upon that, Mr. Valentine?
I think Bob covered it well.
Delegate Lehman, I see your hand is up. Is that from a previous question? Okay. Ladies and gentlemen, as I indicated, there's a motion on the floor and it has been seconded. Is there any discussion on this bill? I'm sorry, Delegate Lehman, go ahead.
I'm sorry, the motion is unfavorable, is that correct?
That is correct. The motion is unfavorable, and that unfavorable motion has been seconded. Is there any additional discussion on HB 942? Delegate Tarasa.
Yeah, I would just say, like, I understand the concern about the automatic termination of the lease, but I do like the piece about clarifying the electricity usage has to be in the lease or it's not on the tenant. Personally, I think there's some value to that, and I don't know where everybody else is on that, but certainly could see that being maintained in some way.
And expand upon, I'm not quite sure I understand what you're.
So I understand the concerns being expressed about the remedy outside of sort of a determination by a court, et cetera. I'm not sure I agree with it, but I do understand the concern about it. But I do like the piece that says a landlord may not charge a tenant unless it's in accordance with the terms of the written lease. I think that clarifies some things and doesn't leave it up to dispute. But I guess it depends on where the rest of the subcommittee is on that piece of it.
Delegate
I
Fraser
agree
Doggo.
with you, Jen.
Thank
Delegate
you.
Fraser Doggo.
Thank you, Mr. Chair. So my overall opinion of this bill at this moment is that there are probably some valid concerns that need to be worked out, but I think that those concerns need to be worked out in a different bill. That's my opinion. I'll be voting against the bill. Thank you.
Any additional, Delegate Siliberti? You're muted, Delegate. You're muted.
Bada boom. Just as an overview, it seems like we are heavily weighted toward tenants. And I am a landlord, and I like for many, many years with several properties. And most landlords do not wear horns. I'm genteel, caring, and work with my tenants when there's a problem. So that's just an observation. Thank you, Mr. Chairman.
You're welcome. Delegate Wells.
Thank you. So I was just I do understand the remedy piece, and I agree that that could be cleaned up. But similar to Delegate Terraza, part of the piece around the electricity, it harkens back to our conversations about definition of rent. And so I felt like in this piece, the legislation is really clear about, the electricity usage is in the lease, but I will support the unfavorable because I do believe that there's more that can be worked out, but I think that there's some things about this that we could improve in another bill. So thank you.
Thank you. The motion is on the floor. The unfavorable motion is on the floor and it has been seconded. Is there any additional discussion? All in favor of the unfavorable signify by saying aye.
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 Any opposition to the unfavorable?
I'm opposed.
Delegate Lehman. Any abstentions to the unfavorable motion? HB 942 will be sending a recommendation to the full committee as an unfavorable motion. It is now 12 o'clock. And I did have one more bill I wanted to discuss, but we have to get into committee at 1:30. Does the subcommittee want to keep plowing forward, or does the subcommittee want to, all right, we'll go to HB 960 is the final bill for this morning. HB 960, ladies and gentlemen, is a bill sponsored by Delegate Conaway, and the bill speaks to lease agreements and estoppel certificates. And there was a lot of testimony on this bill, and the testimony on this bill was unified for an unfavorable motion. And Matthew, there are no amendments on this bill that have been offered. Is that correct?
No, there were none, no amendments that were offered, either in testimony or that I've received subsequently via email.
Okay. I'm now going to go to questions or suggestions by the subcommittee before we go to stakeholders. Any discussion from the subcommittee? I'm seeing none. Any discussion from the stakeholders on HB 960? I see any hands?
Move unfavorable.
A second on the unfavorable? I second on the unfavorable. Any discussion on the unfavorable? All in favor of the unfavorable signify by saying aye.
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 Any opposed to the unfavorable? Any abstentions? Thank you, ladies and gentlemen. HB 960 will be recommended as an unfavorable to the full committee. Ladies and gentlemen, that takes care of our work for today. I appreciate the discussion. We'll be back at this again next week. Same time, same station. I'll be here all week.
Thank you, Mr. Chairman.
Thank you very much.
Mr. Chairman.
Thank you.
Thank you.